As a professor, I view my job as education, educating people about the Constitution, and in particular about our Second Amendment right to keep and bear arms. And I educate not just the people on this channel, but I try to educate judges and lawyers and law clerks and other influencers and scholars around the world. So today I'm unfortunate to have to comment and make some polite criticisms of a good friend of the conservative movement, Fox News' own Professor Jonathan Turley, who overall I'm a huge fan of. But his article about this decision by the Seventh Circuit, the 2-1 decision by Judge Wood against the Second Amendment, well, we got to talk about his op-ed, and you'll see, by the way, when we do so, that I've made you the smartest person in the room. Because when you see the comments he made, you'll see immediately where Jonathan Turley, who's great, went a little bit off the rails on his analysis of this decision and what it means. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxer Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans, and of course Israelis it turns out, all about the right to keep and bear arms. All right folks, so here's the story. Big fan of Jonathan Turley. You see him on Fox News. Obviously, needless to say, I'm a pro-Fox News guy since I appear frequently on that network. With that said, Jonathan Turley, great professor, wrote an op-ed describing his views of the significance and describing the decision by Judge Wood in the Seventh Circuit Court of Appeals dealing with the Illinois quote-unquote assault weapon ban and the magazine ban, which of course is just dealing with semi-automatic rifles and magazines that hold more than 10 rounds, okay? Now, unfortunately, in this piece that Professor Turley wrote, he got a few things, I think, a little bit off about the Second Amendment. So I'd like to clarify some of this so that people don't get confused by this. And maybe I'll even reach out directly to Jonathan and convey some of this information to him myself. But for the moment, I want to use this as a teaching moment because we always like to say that I'm going to make you the smartest person in the room when it comes to the Second Amendment. And that includes being smarter than even fancy-dancy lawyers, professors, scholars, judges, and the like. And I think this illustrates the point that if you've been following my channel, you indeed would have caught some of the mistakes if you were editing this document before it went out. To begin with, Professor Turley, the title of his article, which I'll put a link to down below, you can see if you agree with me, is the Seventh Circuit Rules for the Illinois AR-15 Assault Ban. That's fine. He goes on to say, though, that in a 2-1 decision, the injunction against Illinois' assault weapons ban has been lifted because they concluded that this ban does not violate the Second Amendment. Now, that's all well and good, but then this is where Professor Turley, I think, starts to make some comments that need clarification and correction. The first thing he says is this case could set up a major test for gun rights for the United States Supreme Court. This case could set up a major test for gun rights for the U.S. Supreme Court. Now, that's somewhat correct in that we do need to get a U.S. Supreme Court decision on point that says that AR-15s are protected arms, that semi-automatic rifles are undeniably protected under the Second Amendment, they cannot be banned, and that magazine holding more than 10 rounds or any quote-unquote large-capacity magazines are protected arms and cannot be banned as well under the Second Amendment. We do need that precedent, but it's really not correct. To be very precise, as you know, the legal test dealing with and applicable to arms ban cases, which this is because the Illinois case was involving a ban on semi-automatic rifles of a certain type and a ban on magazines over a certain capacity. These are arms, and because they are arms and they are being banned, guess what? The arms ban law applies. Is there an arms ban precedent on the books? Yes, there is. The United States Supreme Court already resolved how a court is to decide an arms ban case in the 2008 decision of Heller, because in the Heller case, guess what? It decided an arms ban in D.C., specifically a handgun ban, which is a type of arms. That ban was deemed unconstitutional under the Second Amendment because those handguns failed the so-called in common use by Americans for lawful purposes test, i.e., if an arm is in common use by Americans for lawful purposes, such as handguns were, obviously, then they cannot be banned. And the reason why they cannot be banned is a matter of historical tradition of firearms regulation, or specifically a lack thereof, because if arms are in common use by Americans for lawful purposes, they cannot be banned because they are not what is known as dangerous and unusual, because they are not unusual, and thus if they're not unusual, they cannot meet the test, or the government cannot prove that they are dangerous and unusual, and thus they cannot be banned, period, full stop. So when Professor Turley talks about this could set up a major test for gun rights, at one sense he's metaphorically correct, but legally speaking, the legal test for arms ban has already been established by Heller. So frankly, all the Supreme Court would need to do in an arms ban case involving AR-15s is simply to ask the government, do you have proof that AR-15s or magazines that hold more than 10 rounds, that they're not in common use? The government will say, obviously they're in common use. That's why we want to ban them. And it's game over because the legal test has already been established. The government under no circumstances can prove that these are dangerous and unusual. It's obviously these are in common use. It's a game over. So in one sense, it's not a major test for gun rights. It's simply applying an old test from 2008. That's the first thing. The second way that Professor Turley goes off, and this is the sort of thing that a lot of people could make mistakes of over if you're not laser focused on a particular issue or a particular judge, like I am when it comes to the Second Amendment. Specifically, he refers to the majority being composed of, quote, conservative judge Frank Easterbrook and liberal Diane Wood. That's what he says. He describes Frank Easterbrook, Judge Frank Easterbrook, as a conservative. Now, this is a mistake and a bad mistake. I'll tell you why. Because the way Professor Turley wrote this op-ed by saying that a conservative Judge Frank Easterbrook and a liberal Judge Diane Wood got together and said that these AR-15s can be banned, it suggests that this is like bipartisan. It suggests that this is some sort of understanding about how it works. But of course, the reality is that he was a professor, then a judge. Judge Frank Easterbrook, in my view, has not been a conservative, frankly, on any issue since like the 1990s. So I think the data is a little outdated as I see it. But in particular, when you're writing about the Second Amendment, as you know, the last thing you could conceivably call Frank Easterbrook is a modern day conservative, to the extent conservatives are about respecting and honoring and applying the U.S. Constitution as it's written and as it was understood by our founding fathers, to the extent that that is what a conservative is intended to mean, then Judge Frank Easterbrook is 1,000% nowhere near a conservative or originalist or constitutionalist when it comes to our Second Amendment. He is the absolute 100-degree polar opposite of that, because he is absolutely pathetic, terrible. I cannot come up with even worse adjectives than that. I probably can, but I don't want to get kicked off YouTube. So yes, he's terrible. So in this op-ed for Professor Turley to refer to Frank Easterbrook as conservative gives Frank Easterbrook cover as if this is somehow an honest opinion. It's not. He's not conservative, and he certainly is not conservative in the traditional sense when it comes to our Second Amendment rights. So that is another exception I take to Professor Turley's article here. The third mistake is, and now we're going to start to get into things that you would have been able to flag if you edited this piece before it went out. Professor Turley says that the court further noted that the Supreme Court has previously found that machine guns are not protected under the Second Amendment because they are not bearable arms under the Second Amendment. This is wrong on a lot of levels. To begin with, before we get into analyzing machine guns, I want to say one thing. In the Second Amendment community, we have to be incrementalist. And what that means is we first have to win at the Supreme Court that AR-15s are protected by the Second Amendment and cannot be banned. We then need to win magazines that hold more than 10 rounds. Then we can go on and talk about other items as I see it. Suppressors, short barrel rifles, short barrel shotguns, yes, maybe even machine guns. But if you think about how things worked, let's say in World War II, you couldn't just invade Japan. You had to go into the Pacific and you had to island hop. You had to take over Iwo Jima. You had to take over Okinawa. You had to take over these islands on the way to Japan. You couldn't just go to Japan. For those of you who are upset with me that I sometimes say we can't talk about machine guns now, it's not that I don't want to, it's just we have to be smart about this. The only way we can get to machine guns down the road and talking about the issues associated with machine guns is we have to first win these other issues. Just like you can't just invade Japan, you have to capture the islands along the way. We have to be incremental, step by step by step. So again, the reason why I bring this up is even though here Professor Turley's talking about machine guns, he still analyzed it incorrectly. Specifically, he says that they found that machine guns are not protected under the Second Amendment because they're not bearable arms. This is not accurate. Remember, we know how this works, and we know what Heller did, and Bruin did the same thing. You start with the text of the Second Amendment. What does the text of the Second Amendment say? The operative clause is the right of the people to keep and bear arms shall not be infringed. Did the Supreme Court define arms? Yes, it did. The U.S. Supreme Court in Heller defined arms as anything that can be used offensively or defensively, including body armor, quoting professors, I should say lexicographers who are creators of dictionary in the 18th century, such as Samuel Johnson. So the Supreme Court has already defined arms, all arms, as anything that can be used offensively or defensively. So can a machine gun be used offensively or defensively? Yes. Therefore, a machine gun is an arm under the text of the Second Amendment. So are AR-15s, so are knives, so are magazines, because they're essential components of these types of modern firearms. Okay? So here's the thing. Textually, they're protected. So then the burden shifts, as you know, to the government to show, is there a historical tradition of regulating or banning these kinds of weapons? The only thing in Heller that the Supreme Court came up with is they said, look, the only thing in American tradition is there is a history of banning, at least the banning of carriage, meaning carrying, banning carrying of dangerous and unusual weapons. And therefore, and again, they just said, look, therefore, since handguns are in common use, they're not dangerous, unusual, they're protected. Okay, so what they're talking about here, what Professor Turley's talking about, is there is a passing reference in Heller indicating that machine guns would be something that would be considered dangerous and unusual and not in common use by Americans for lawful purposes. Now, that was not the official holding, but that was an indication of where the Supreme Court was going. But it didn't officially say that machine guns, and they didn't say machine guns are not fall under the text of the Second Amendment. They just said that the historical tradition of banning dangerous and unusual weapons and machine guns likely constitutes one of those things. And regardless, as a matter of fact, under no circumstances can a semi-automatic rifle be dangerous and unusual, in addition to the fact they're in common use. We also know from the 1994 Supreme Court decision of Staples versus United States, the Supreme Court itself said that semi-automatic rifles and semi-automatic firearms are, ubiquitous. Everyone has one, and it's not unusual to have these at all in American life. That was a Supreme Court decision, and a big one at that, and that's why you always look for the Staples opinion. But let's go on about going back to what Professor Turley writes. So again, it wasn't that machine guns are not protected because they are, quote-unquote, were not bearable arms. That's not accurate, because obviously a machine gun is an arm, and it is a bearable arm because A, it's an arm, you can use it offensively, defensively, and it's bearable because you can carry a machine gun. The reason why arguably machine guns are not protected is not at the textual level of what an arm is, it's at the historical level of it conceivably could be a dangerous and unusual weapon, and thus at a historical level can be banned and regulated. Again, the Supreme Court hasn't officially held that, but in Heller it indicated that's where it was going, and again, we don't want to fight that out. We have other things we have to win before we talk about machine guns. But again, just to clarify what Professor Turley said, it's not entirely precisely correct. So let us carry on. The next area where, and again, I'm not beating up Professor Turley here. I just want you to understand things that we want to learn from when people make mistakes or people don't quite get it right. I'm not doing this to beat up Professor Turley, who I really, really like, but if Judge Benitez make mistakes, I call him out too. If people that I consider to be on our team make mistakes, I call them out, not in a mean way, but to help educate them so they improve and they don't make mistakes that help the anti-gunners or the leftists in America. And I'm sure Professor Turley has no interest in helping out the group. At least that's my best speculative guess. Okay, let us carry on. Professor Turley in this article then starts to talk about how AR-15s are like M16s, and he starts analyzing things like velocity. He starts talking about the 5 fastest rifle cartridges. He talks about the velocity of these various weapons and kinetic energy, and starting to draw these analogies. But again, this is 100% unnecessary, and we do not want to talk about this kind of argument, because if you do so, you play into the left-wing anti-gun game. What the left in America wants you to do is to pretend and be duped into the notion that the Heller 2008 case is not the law of the land when you're dealing with arms cases. They want to pretend that the only Supreme Court precedent that we even consider is the Bruen case and not Heller. And the reason why the anti-gunners want that is because they already have lost Heller, and Heller set up that legal standard of in common use by Americans for lawful purposes that under no set of circumstances can they possibly prevail on in their bans of AR-15s, semi-automatic rifles, or magazines that hold more than 10 rounds, and arguably including short barrel rifles and short barrel shotguns, but again, that's for another day. So the point is, this is why the anti-gunners in America are desperate to make all of us in the United States, including Professor Turley, mind you, to try to pretend or ignore or err in that the Heller case is not good law, because the Heller case is very good for the Second Amendment community, and we never want to lose sight of that. Now let us carry on. So again, the issue is not feet per second, it's not velocity bullets, and not comparing, AR-15s with protected handguns or any of that. The only issue is, what do Americans pick? Remember, Heller said, and this is again why the anti-gunners want to pretend that Heller is not good law and everyone wants to talk about Bruen. Do not play that game. It is a terrible mistake. Heller is the law of the land for arms ban cases. It's consistent with Bruen. Heller and Bruen are totally consistent with each other, but Bruen set forth the legal test for arms ban. Never lose sight of this. And keep in mind, the reason why Heller is so good for us is the U.S. Supreme Court said that the only thing that matters as to whether or not a gun is protected is what do Americans, what do we the people pick in terms of what we want to protect ourselves? Specifically in Heller, this is what the Supreme Court wrote in explaining that handguns are in common use and cannot be banned. This is what they wrote, quote, whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid, period, close quote. Hear what I just said? The Supreme Court, in explaining why handguns cannot be banned, and by the way, as a reminder, there was no expert testimony in Heller, no expert testimony in Bruen, no expert testimony in any of these cases. Okay, you don't need experts. There's no discussion how many times people pulled a trigger of a handgun. None of that matters. None of that matters. Do not get sucked in by the anti-gunner arguments. The only thing that matters is what the Supreme Court said, as I quote, whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid. Point being that we, the people, get to decide what arms we choose to protect ourselves, our families, and our communities. No government on high gets to tell us what's best for us. No crazy judges in Chicago get to tell us what we can and cannot have. That's not how it works. That's not Mark Smith. That's not the Four Boxes Diner talking. That is the U.S. Supreme Court in Heller. And never forget, the anti-gunners want you to pretend that Heller doesn't exist and that Bruen somehow overrode Heller. It is not true. Heller is a fantastic case for us. Always embrace Heller. Don't let them bury it. Don't let them pretend that Bruen is the key, because, again, they want to be able to re-argue Heller, but they've already lost. Don't re-argue things that we've already won. It is a hill we've taken. It is a hill we control. That is the Heller hill. That is the in common use hill. It's a fantastic hill for us. Don't lose it with sloppiness and whatnot. So, all right, folks, hope you learned a little bit something here today. Professor Turley does a great job. I really enjoy watching on Fox News, and I like reading what he writes. But on this op-ed, I thought we had to get some clarification and finagling here, clean up a little bit, and I hope that helped here. And again, if you haven't subscribed to the Four Boxes Diner, please do so, and don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.